Okay. So, let's see. I've got Ms. Busse's counsel.
Yes, Your Honor. Good afternoon. Michael Williams Scholes. I'm counsel for Ms. Busse, the petitioner in this matter. I'd be happy to kind of walk you through where we're at procedurally, if that's helpful.
Yeah, it would be, especially if there have been any sort of developments.
Well, Your Honor, we filed a request to register the Virginia orders here in Utah a little while back. Well, quite frankly, some time back. Now, that's because both she and the child in question live in Utah and have lived in Utah since September of 2023, Your Honor. Now, that meets the requirements. Mr. Busse did, however, file an objection, or rather, he requested a hearing. He never stated, and we're hoping to hear today about that, never stated whether or not he actually objects, which is a requirement to be here today. But to get things moving, my side, we actually reached out to your court to set today's hearing. And we've been here a while. We hear you're very busy. Very much appreciate you making the time. We did that because we need to get moving here. Nobody lives in Virginia. Mr. Busse lives in Ghana, and my client and her child are here. All we're asking is for Utah to retain permanent jurisdiction over this matter. And yes, Your Honor took the time to have that phone conference and did decide, we listened to the call, that we should have temporary jurisdiction. All we're asking is for that to be made permanent. And all we've heard from the other side today is that no notice was provided. But that's just not true. Notice was provided to Mr. Busse back on December 16th of last year at his known address, the state where he was living, and the same address that was listed on his request of service. We know he got it. And it's only after that notice that he requested this hearing. So I'm happy to stop there unless the court has any questions for me and turn the time over to Mr. Busse. We're just trying to get things done for these folks. And we apologize that we even needed to be here today. I'd like to get this done so we can move forward with our petition to modify. Thank you.
Okay. I'm just looking over the docket. There was a notice of registration of foreign child custody or parent time order through the UCCJEA Utah Code 78B-13-305 that was sent out to Mr. Busse at the address at the time. This was back on December 16th of 25. The address we had for Mr. Busse was 1529 Courthouse Road, Unit B in Stafford, Virginia, 22554. That was sent out by my clerk, Ms. Abby Bell. And I don't know, following that notice, that we got anything back reflecting that the notice was not successful. On the 29th of December, the court received from Mr. Busse, which I think would reflect that he did receive the notice, a request for hearing. I'm just looking, it says December 23rd, 25, address 1529B Courthouse Road, Stafford, Virginia. There's a phone number listed, and the subject line is request for hearing. And then it says, on or about December 22nd, 2025, I received a notice of registration of foreign child custody or parent time order, case number, and then my name. I contest the validity of said order. I am the parent of the subject minor, Bridget Ellen Busse. I reside in Virginia. I have joint legal and physical custody. And then he says, I was never given notice of any hearing in any foreign court. To my knowledge, notice was not given pursuant to 78B-13-108. I request a hearing to contest the validity of the order in question in the above identified case. So it's a little unclear to me as to which order was being contested. We're talking about just registering a previously entered order. if I'm not mistaken, right?
Your Honor, that's exactly correct. And no notice of a hearing could have been provided because there was no hearing. So you're right on we're on the same page.
Yeah, so there was a child custody order that was entered. And I just want to make sure I'm looking at the right one here. Just bear with me for a minute.
Certainly.
So this is out of Virginia. It's in the Juvenile and Domestic Relations Court of, if I'm reading this right, Culpeper
Yes, Your Honor.
County.
Yes, Your Honor. That's correct.
Yeah, in Ray, Bridget Ellen Busse, and then there's a long case number there, and it says corrected custody and visitation order, and then there's below that the order itself with some handwritten notations in the order. It's ultimately there are a lot of signatures on here. It's difficult to read the signatures. One of the signatures, of course, underneath it says judge. And then
Your Honor, pardon me. May I am Mr. Busse's Virginia attorney. I understand I'm very limited what I can say here, but if I could help the court just by adding some clarity as to what the filing was, that was my intention.
No, absolutely. In fact, all I was trying to do was just try to establish what order we were talking about. That they were trying to register here in Utah, where Mr. Busse was saying, I contest the order. I just wanted to make a record that there was an order out of Virginia that he knew about, was a part of, and that all that was occurring in my case was they're just trying to register it here for the purpose of going forward with a modification. That's all.
Absolutely. And the registration that my client received of, which I said, I don't practice in Utah, seemed to say it has been registered as an order. And sometimes the way that it's written, it is my understanding it was my client's objection to the registration. So when he's saying the order is invalid, he was referring to the registration order. That was the understanding. The order is a valid order. And I've said, I'm also here to the extent the court wants to hear anything about jurisdictional disputes or what's going on in Virginia. I'm happy to. I understand Your Honor had a meeting with Judge Larson and probably has a full understanding, but I guess I just want to explain why you have an attorney with a VA bar number in your courtroom, Your Honor.
No, and you know what? I welcome your help. I really do. I'm not in any way offended at you participating in this process, notwithstanding the fact that you're a Virginia attorney. Any help you can provide is welcomed by me. I think, it's been a minute since Judge Larson and I visited on this matter, but she and I, after discussing sort of mom and the child being here in Utah since 23, and forgive me for not remembering if when I met with Judge Larson, if dad was still living in Virginia or not, or if he had already relocated to Guam. But be that as it may, I think Judge Larson and I concluded that she had very little contact involvement with the case and felt as though Utah would be much preferred in terms of a forum in which to deal with any sort of modification request. But I said, well, under our statute, dad has the right to present evidence to suggest that jurisdiction remain with Virginia and not come here to Utah. And so that's why we continued it, was to give dad a chance to sort of figure that out. Now, am I to understand, Mr. Busse, that between that hearing and today, you have relocated to Guam? Is that where I was told you're living now?
No, correctly in Ghana.
Oh, Ghana. Sorry. Yes. I don't know why I thought I got the G right.
Right. Same live number of letters too.
It feels this far.
Yeah.
And if I can, if you can bear with me, I can kind of maybe lay out a little groundwork. And I knew by late fall last year that I was transferring, that I was going to be transferred here to Ghana. And in anticipation of that, I had prepared I had discussed with Shannon possible changes to something had to change because I was moving. The current custody order involved airport exchanges at Washington, D.C. and things like that, and those had to change. So I had filed, I think it's almost, the universe works in mysterious ways. I think that Shannon was probably preparing with her attorney to register it. I was preparing a little bit on my own, a little bit with an attorney to file. I had filed a motion, and it was actually filed in Culpeper Court in Culpeper, Virginia on December 18th. I was completely unaware, in the dark, and I thought I was doing the right thing to get custody order modified to fit my reality, to fit my upcoming reality. And so on the 18th, I had filed my motion, and I had expected that then we'd have a hearing to make an order that works out best for everyone, parents and kids. And it was December 22nd or so. Service was not immediate. I did not get emails, nothing like that. I did get the notice later in the mail. And as we can see now, you can have 3 or 4 paid legal professionals in the room and still have to maybe check references for UCCJEA. So I was responding immediately as fast as I could to say, well, pump the brakes. I just filed. Let's get the custody order right, and then let's proceed with who has jurisdiction of that. So that's a little bit of the background. And preparing for international.
If I may jump in here for clarification, and Your Honor, once again, I'm not trying to step outside of my lane here, but generally my experience, so, we're allowed to jump in here, but I just want to add a little bit of clarification. The motion that was filed on behalf of Mr. Busse was not a motion to modify custody. It is solely a motion to modify his visitation.
Okay.
And that, to the extent the court wants to hear any arguments about the slight discrepancy, the differences in Virginia, and why that is Mr. Busse, we would state that enhances why transferring jurisdiction is less necessary, given that the requested changes are small. I'm happy to make that. John, sorry to interrupt you, but I just wanted to clarify that.
No, thank you for simplifying it. Yeah.
And Your Honor, for our 2 cents, first of all, we definitely have no objection to Mr. Schultz being here. In fact, he and I have been working in good faith across lines, and so have the parties in good faith to simply resolve this matter via stipulation and not via litigation. Those efforts are underway, and certainly everyone's given it a good cause to try. I'm happy that he's here. I'm grateful for his support across those legal lines. We're not here seeking a sanction or a penalty, or even necessarily saying that Mr. Busse is wrong. We're here today simply saying, let's get it moving. Both sides in this case, I don't believe it's any secret, we've heard a little bit from the respondent, have an interest in modifying the existing decree. And it is true. And I'm willing to take on credit that, like ships in the night, both sides sort of passed each other by in the December of last year. We're okay sort of letting bygones be bygones. I would like to get things moving here today and simply say both sides want to modify. Utah is the appropriate forum. We're happy to receive, if Mr. Busse would like to file, we're prepared to file here and then engage in mediation and just get this done. And definitely, I love what you said about judicial settlement conferences. We have a phenomenal track record with those these last few years. Love those. I think we can get this done. I'd just rather get on with it, please.
I understand. And so again, circling back around, at the time of our settlement at the time of the UCCJEA conference with Judge Larson, the parties were not present. And after she and I discussed the matter, in reviewing section 81-11-109, which is the UCCJEA statute here in Utah that deals with communication between courts. In subparagraph 3A and B, it reads as follows. The court may allow the parties to participate in the communication. And that did not occur. I think it may have been a timing issue. I'm not sure what was going on at the time. But then B sort of covers that when it says, if the parties are not able to participate in the communication, the parties shall be given the opportunity to present facts and legal arguments before a decision on jurisdiction is made. And that was the purpose for continuing it to today, was to give Mr. Busse a chance, and I suppose to a degree, Ms. Busse as well, an opportunity to make argument as to where jurisdiction should lie. Knowing, of course, that Judge Larson felt initially that it should be here. And I simply told her that I would not make a decision until the parties had been given the opportunity that the statute contemplates to make those arguments. So maybe that's where we are, unless Mr. Busse is saying, look, I'm fine with Utah handling this, since all we're talking about is parent time and how we're going to make arrangements for that with him now being in Ghana. We can keep it here and I can handle that. If there's some benefit to having it in Virginia that I'm not seeing, I guess I can hear argument on that. It's your call, Mr. Busse. At least if you say I'm fine with Utah, then we're done with today's hearing, and all we need to do is allow the registration to move forward, and then you folks can continue to talk, with the idea being you can work something out with the transportation of your child. And if things kind of break down, then you'll come back to me and we'll deal with it. Otherwise, you can get it all worked out. If you want to insist on jurisdiction staying in Virginia, then I'm going to need to hear argument from you or from your Virginia attorney on why Virginia should be the place where this should go.
Your Honor, I am prepared to make argument on behalf of my client as to why Virginia should retain jurisdiction.
Okay.
Your Honor, in this particular case, while I understand the minor child is currently residing in Utah, it has been in Virginia, been with child support, custody, and visitation for years, even though the relocation to Utah happened about 3 years ago. The parties have extensive history with Judge Larson and the court. In fact, that was a factor in the mother's payment of some, without getting into the weeds, mother was obligated to pay father some attorney's fees. And Judge Larson was able to determine that by looking at a previous child support order that was in the court. Additionally, this is just a father is already an extended custody case, right, where they live in different states. And not to undermine my client's claim of a material change in circumstance or whatever the Utah equivalent is, his relocation to Ghana does change some things. But in reality, it changes around the edges. How long summer is going to be, how long winter, what will spring break be, things of that nature. Given that the only material change, excuse me, Your Honor, but I've been told to be as clear as possible. In Virginia, we have to say this X reason, this is our material change, and this is why we are asking for this new schedule. I'm sure Your Honor knows, but I just want to be clear. But the only change that has been alleged by my client is the change in his career, his path, and his location. All of that information, to the extent it would be in either state, would be in Virginia. If he were to, that's the entirety of the case. We're not asking, or at least I haven't asked for custody to be changed. We haven't alleged that the minor child is failing in school, is using drugs, anything like that. If that was the case, certainly Utah, we'd need to be talking to the therapists, the school teachers, the doctors. We would certainly need to be getting into all that. And of course, Utah would probably be better at that point. There's no question about it. But given that the facts of this case, really the material changes and the key focus in it is father's moving. He still spends some time. He has to come back for work. And if he does, that'll be in the DC, Virginia area, right? I don't want to say exclusive, but the pretty much exclusive issues will end up relating to Virginia. Additionally, Your Honor, part of the objection, and admittedly, it probably has a little bit less weight than it did a few months ago. I believe my client can correct me. I believe there's only one summer left before the minor child turns 18. John, is that correct?
No, actually, we have to prepare all the way out to 2028. So this summer is underway. She's here now with me in Ghana.
2 more.
And so we're looking at summer 27 and summer 28. And then immediately after that summer, she turns 18. And
Okay,
so
thank you. So 2 more summers. So additionally, a little bit of the worry is trying to get it on the court's docket as soon as possible. There's already been filings and proceedings in Virginia, and to, unfortunately, feel like the case may have to start over in Utah would delay it. And then there's a last point of clarity. I think so, and this may be out of my wheelhouse, so I don't want to step in too much. I think there was also a request for child support to be registered in Utah. But that's not what we're discussing here today, right, Your Honor? This is just in the custody and visitation, because child support would be a separate issue with like personal jurisdiction over my client and all that sort of stuff.
Yeah, I mean, I didn't go through the entire order that was registered, but whatever that order encompassed and was registered, then that, of course, would be, I suppose, fair game for a modification if one was justified.
And that's exactly right, Your Honor. It is more than just one thing. It's interesting. We're hearing argument that a proposed modification by the respondent is narrow enough. We're hearing, since it's just for 1 or 2 things, then it's not necessary to have it here. Your Honor, that's not why we're here. We're here because Mrs. Busse filed a registration so that she can seek modification of a variety of terms contained in the decree. We did this, not Mr. Busse. So I understand and I appreciate the unfortunate position that counsel is placed in, because I'm heartened by their words. We just heard from the respondent via proffer that if it was about more than just what Mr. Busse wanted, if it was about more than 1 or 2 things, then I think I'm going to be able to quote here, then of course Utah would be the appropriate forum. Your Honor, we are here because Ms. Busse is seeking modification. She's been waiting to file it until this jurisdictional matter was resolved out of respect and to not attempt to be muddy in the waters. We are not here because of Mr. Busse's narrow ask in Virginia where nobody lives and the child hasn't for years. We're here because she's seeking modification of a variety of things. And she's been unable to do so because Mr. Busse isn't accepting the fact that this is the appropriate forum. If he wants to get things done, that's what needs to happen. We meet the requirements under statute. The Virginia judge has said that jurisdiction is appropriate here. And we've heard from the respondent via counsel that if it was more than just a narrow modification of 1 or 2 issues, that Utah would absolutely be the appropriate forum. Your Honor, I'm sitting here telling you that's exactly what we're doing. And we need to get it done. And this is not going to prejudice Mr. Busse in any way. Utah is a wonderful place to get things done. It's the appropriate place, and it's the only place, we've just heard from both sides, where the amount of modification necessary being sought by the petitioner can be accomplished. Does Your Honor have any questions about that or anything else for me?
I need to speak, if I may.
Yeah, before you do, I wanted to speak. Counsel, do you pronounce your last name Schultz or?
Yes, Schultz, Your Honor. I was getting really confused with the other attorney who was called Schultz in here earlier.
Yeah.
Well, mine is Scholes or Scholes. I've answered the worst, so maybe we can go by Theseus, which is such an excellent name.
That's fine too.
Well, Mr. Schultz, I'm wondering, and this isn't a way to sort of do an end around our discussion, but it seems like it would be very understandable if Mr. Busse said, I've got this great attorney in Virginia and I'm going to lose him if this case goes to Utah.
I was trying not to toot my own horn, Your Honor, but yes, I mean, he spent thousands of dollars on my representation so far.
But why couldn't you file a pro hoc vice request and this court grant permission for you to appear pro hoc vice on this case and handle it, notwithstanding the fact that you're in Virginia, removing that concern. Now, granted, there would be a little bit of a disadvantage for you in that you'd have to work within our statutory schemes and rules. But quite honestly, my experience has been that while the terminology may be slightly different, the principles are the same. And so I don't think that you would find that things are so, foreign here in Utah as compared with the way things are done in Virginia, that it would be a nightmare for you. But my thought about that is simply to say, look, if that's part of the issue, that he would then need to find a new attorney, I get that. Like, I can understand why that's a problem. And what I'm trying to do is figure out, well, why couldn't we do that? I don't suspect Mr. Scholes is going to put up a fight and say, absolutely not. In fact, it sounds like you and he have already been in discussions, and those have been productive. What are your thoughts about that?
I'm always up for something, try something new. I would have to confirm that with my client. I would, if the court were to do that, I would just ask the court to include an order that if it is chosen, that Theseus Schultz can have be admitted pro hoc vice in. But I wouldn't want to stand here today and tell you, yes, my client will hire me to do that, because I just don't know. But if you could leave that door open, that would be certainly a remedy, assuage a significant issue.
Okay. And to be clear, we would happily stipulate to support that action. I think it would definitely help us get things done. And again, we're really close already without going into confidential details. And everybody's motivated to do this while the child has this opportunity for time with father and with mother, but during these last few summers. So I think that's an excellent idea, Judge.
Mr. Busse?
Your Honor, briefly, to the extent the court were to do that, I would just simply ask the court to reserve determination regarding, and I know this is a little bit off what we're talking about, but reserve determination whether Utah has jurisdiction over my client for child support matters. I know in Virginia they wouldn't. I would have to go look up Utah, but I would ask the court to just reserve that finding, because if I were to be obtained and I found that it wasn't, I would like to be able to make that argument.
I would certainly allow that to be briefed and argued before the court made a determination, at least on that issue. Certainly.
If I may say, the opposing counsel has overtly said that once this settles in a case, I'm expecting a flurry of motions and sounds like legal battles ahead. Therefore, Virginia becomes the court of convenience. My employer is based in Virginia. I will return periodically for various reasons to Virginia. Utah is clearly not convenient, and it would be hideously expensive for me to travel there, to recruit and retrain a new attorney, to try to learn those laws. We're all familiar. Shannon and I are both familiar with the Utah courts. And regarding, I would just like to put an asterisk here as far as the child support issue, not the visitation. That's covered under the Uniform Interstate Family Support Act, UIFSA, which is federal law 21 USC 1738B. So we are not, that has never been entertained so far, that we're talking about custody only and not support. But anyway, so to point out that I'm being warned that whenever this settles in any given court, that I'm going to have to, sounds like I'm going to have to start making regular trips to a courthouse, that Virginia is clearly more convenient.
You know, that's just simply not true. It's no mystery, nor has it ever been, that the whole reason for this action to begin, that's brought us here today, is so that there can be modification. It's not a flurry of suits. It's a petition to modify if the parties are unable to resolve. The idea that that we're going to consider Mr. Busse's inconvenience and his fees, well, let's do that. We're all here via WebEx, and someone's not, Mr. Busse, I believe, is in another country. So we clearly don't have an issue of access. And I would happily proffer and be happy to provide to the court that Ms. Busse has incurred the same or more legal expenses, and all she's been trying to do is have an opportunity to be heard. So if we're going to consider inconvenience, I think both parties have been inconvenienced. And the idea that we're going to proceed with this jurisdictional back and forth instead of get to the heart of the issues doesn't serve anybody, neither party nor the minor child.
Your Honor, if I just may very, very briefly, I don't know of any conversations that were had directly with my client, and I had very limited but admittedly troubled conversations with Mother's Virginia attorney. I have not heard anything from Mr. Scholes regarding directly to me. He's been extremely professional, and in fact has granted me grace when I probably didn't deserve it. So I just want to probably put that out there for Your Honor.
Okay. Well, I think one thing that has changed since our last time together is that Mr. Busse has now relocated by way of a job transfer to Ghana. And while it is true that he will be returning to the Virginia, DC area periodically, at least I think it would be reasonable for the court to make a finding that he is residing in Ghana, not in Virginia and the DC area, although work may bring him back to that area periodically. Mom has resided in the state of Utah since, if I got the date right, September of 2023.
Yes, Your Honor, that's correct.
I think it's also significant to a degree that the court make the observation that we're not talking about a young child. We're talking about a child that, or a young lady, I should say, that is on the verge of emancipating. I mean, we're very close to that. And so I often kind of snicker to myself because when parents are fighting over time with a 16-year-old or 17-year-old, I often think to myself, well, those youngsters are pretty willful, and moms and dads can say, well, you're going to go visit your mom or you're going to go visit your dad. And the 16 or 17-year-old can say, yeah, bet me. And so, you know, it's often difficult for the court when you have parents saying, well, my child won't come see me. And the other parent says, well, I've done everything I can to make them go, but they refuse. It's a little different when you're dealing with smaller children, right? So, you know, some of these issues may, at the end of the day, not be as serious or significant as they would seem to be. As I consider the issues before me and the arguments that have been made and the facts that have been presented, which is what 8111-109 suggests, in this court's view, the parties have a much closer connection presently to the state of Utah than to the state of Virginia. And that, in my view, is most strongly supported by the finding that mom and the young lady, the daughter in this case, have resided here in Utah for, well, we're coming up this September, 3 years. And to me, that seems quite significant. I think it's also important to note that Judge Larson felt that there was very little connection to the state of Virginia. And those were her kind of observations. She felt that Utah was the appropriate forum for this case, and but didn't want to step on my toes. And so I said, well, let me afford Dad a chance to.
I've lost.
Are you there, Mr. Busse?
I seized up there. I'm sorry.
That's okay. Can you hear me now?
Yes, sir.
Okay. I was just observing that Judge Larson also felt that Utah had a stronger connection to the issues in this case than Virginia did. The one issue that, of course, tips the scale slightly back in the other direction is the fact that, you've had a lawyer, Mr. Schultz, in Virginia who's worked with you for some time. And I can understand the challenge of saying, well, now I got to start all over with a whole new lawyer. who doesn't know anything about the issues in the case. And that's why I made the suggestion that Mr. Schultz submit a request motion to appear pro hoc vice, and I could grant that motion and permit him to appear on this case. We do those types of pro hoc vice orders in limited cases. We don't do them very often, but every now and again we get a request to do them, and I think this is certainly one of those times when it would make sense to do that. And so I'm kind of letting him know in an advisory capacity that if he were to file such a motion before me, I would likely grant that motion and permit him to appear on this case for you, assuming that you wanted him to continue in his representation, not obligating you to have him, but just letting you know that if you want to keep him, I would permit him to appear on this case for you, even though he isn't licensed here in the state of Utah. And so I think that's how we maybe solve that issue. So I'm going to find under 8111-109 that Utah will retain jurisdiction over the issues in this case and allow the registration of the order from Virginia to stand. And then, go ahead. Was there a question?
I didn't see.
And then I think where we are is, well, I guess where we are is allowing council to meet, confer, with the idea being to try to come to a resolution.
Oh, I think you've frozen again.
Your Honor, I may humbly suggest, because I'm an IT nerd, that if everybody turns off their video, or perhaps if Mr. Busse turns off his video, his remaining bandwidth will be sufficient for audio.
Yeah. Okay, well, with the case now being registered here in Utah, I think we move forward just like any other case where the council confer, try to see if there's a way to resolve it moving forward. And if not, we do have an order in place, and we do have, I believe, you indicated there was a petition to modify that had been filed. Is that right?
Yes, Your Honor, I'm sorry, one other thing that's absolutely crucial. I believe I'm pulling it up right now. There was a temporary order entered by Judge Larson. I believe it is on March 27th, that modified certain terms. I'm sorry for interrupting, but I don't believe the court has a copy of that, just because obviously it wasn't in effect when the mother filed the initial registration. This was the last hearing in front of Judge Larson prior to this meeting.
Well, so let me just think that through with you for a moment. So the order was registered in Utah, and you're saying that after that occurred, there was a temporary order that Judge Larson entered? I'm a little unclear about the sequence of events.
Sure. So as both filings happened effectively simultaneously, the matter continued going in, and this is all without attempting to change Your Honor's mind. Your Honor's made the decision on registration fairly clear. While the objection was pending, the matter continued to go on in Virginia. There was a couple of status hearings in which there's a couple of status hearings. Judge Larson ordered mother to provide any evidence of anything that was moving forward in Utah. Nothing had moved forward in Utah. We appeared on the scheduled trial date, which I believe was March 27th. I can double check that. Yes, March 27th. At that date, that's when mother obtained Virginia counsel who said there's an order in Utah, et cetera, et cetera. Judge Larson, I think at that point, and I say this with complete respect, probably got a little bit of cold feet going forward and said, I'm not going to handle a full trial, but did make temporary changes to the order because father was going to be relocating. Okay. And so the court has already made the determination regarding registration, but I would just, I guess, also ask that this court also register the temporary order as a temporary order, but so that way they're not going backward in time.
No, I understand. And I mean, I'm not troubled by that request. In fact, I was thinking that's where you were headed. And I was thinking that any orders pertaining to this case that are coming out of Virginia, if Utah is going to retain the case, then those orders need to be registered, including the temporary order that pertains to the case. So Mr. Scholes, I guess I would, if we're going to register the original order, we ought to register the temporary order that goes with it.
Yes, sir. We have certainly no objection to that. And I was going to bring that up to him. I think we're all on the same. Hey, we might all be on the same page for once. Here we go.
Okay.
Very, very true. And for what it's worth, we needed that as a temporary order to bring her to Ghana. So otherwise she'd have to be in an airport in DC.
Oh,
So,
okay.
all right.
Well, and it sounds like she's in Ghana now.
Yes, Your Honor.
Okay. All right.
And
Well-
I will say that as far as the process, we did in December. The opposing counsels mentioned that they do want to get things going. In December, I filed to make those visitation changes. So I think we all see the need. So I think we're all motivated.
Okay. Well, I think we're good in terms of what we needed to discuss today and the decision the court needed to make. And Mr. Schultz, I will await your motion to appear pro hoc vice. If you'll submit that along with an order, I'm happy to sign it. And then I think that will permit you to handle the matter. Again, assuming Mr. Busse wants you to stay on the case. I don't want to suggest that you have to be kept on the case, but assuming he does, you can visit with him offline. And if that's what he wants, then file the motion and file the order. I'll sign it. And then you and Mr. Scholes can continue discussing the matter with the idea being to try to come to a resolution of some sort.
Thank you, Your Honor. I'll discuss with him, and to the extent that it's filed, I'll direct it to your attention. Additionally, said I made my request earlier regarding the child support personal jurisdiction issue. Additionally, and I'm not sure how Your Honor and these courts handle it, but I would ask the court to include in the order, to the extent possible, that permission to appear virtually for my client and to the extent myself liberally granted.
Absolutely. I'm happy to accommodate virtual appearances for you. I don't expect you to be traveling back and forth to the state of Utah. And I don't expect Mr. Busse to be traveling back and forth from Ghana to Utah. I'm happy to accommodate virtual appearances to keep everyone's costs down. So yeah, no worries there.
Thank you, Your Honor. I just know in Virginia, we got to have everything in the order. So that's why I'm just making all the requests. I appreciate that.
Yeah, of course.
Yeah, thank you.
Of course. Okay.
Nothing further.
Well, thank you all for your time this afternoon. I appreciate it very much. And I'll await the order. Perhaps, Mr. Scholes, you could prepare the order from today's hearing, reflecting that the court is going to exercise jurisdiction over the matter. And Mr. Schultz can submit, again, assuming that he stays on the case, his motion to appear pro hoc vice along with an order. And he can include in that order the permission to appear virtually for both him and his client. So we'll just have each of you prepare separate orders since they deal with different things.
Yes, Your Honor. Very happy to do so. And thank you for taking so much time for us today. And thank you to counsel as well.
Okay.
Thank you. Have a great day.
Thank you, everyone. All right. Take care.
Thank you, Your Honor. I appreciate it. Thank you.